This is Duke University.
Hello and welcome to today's Federalist Society debate on the Affordable Care Act. We're going to discuss whether the Supreme Court got it right. As our own Professor Sachs said, just because the act was held constitutional does not mean it is constitutional. I would like to thank the American Constitutional Society for co-sponsoring the event. I'd like to extend a special thanks to the Templeton Foundation for funding this event. As part of that funding, they would like you to fill out the surveys that you have in front of you. Please fill out the blue portion now before the debate starts, and the yellow portion after the debate is over. And when you leave, if you can hand those to our volunteers that will be standing at the door, and if you leave early, just put them on the tables where the food were at, and we'll collect those up. We have two great speakers today. Mr. Ilya Shapiro is a senior fellow at the Cato Institute. He comes to us by way of Princeton, London School of Economics, and University of Chicago Law School. After clerking on the Fifth Circuit, Mr. Shapiro practiced litigation for several years and served some time in Iraq doing rule of law issues. Since joining the Cato Institute, his commentary has been published in scholarly and popular journals such as the Harvard Journal of Law and Public Policy and the Wall Street Journal. You may have also seen him on the Colbert Report. Although today's debate is in English, he could debate it in 5 other languages if need be: Russian, Spanish, French, Italian, and Portuguese. Professor Siegel is well known, so I'll only give a brief synopsis of his stellar background. A graduate of Duke University and UC Berkeley Law School, Professor Siegel served as a Bristow Fellow, the Office of Solicitor General, and clerk for Justice Ginsburg on the Supreme Court before returning home to Duke. Please give both speakers a warm welcome. The format of the debate will be, each side will be given 15 minutes, and following those 15 minutes, each side will get 5 more minutes of rebuttal, and following that, questions from the audience. You can submit questions to me via email during the event if you like, johnny.havens@gmail.com or jph27@duke.edu. We already have a couple pre-submitted questions that we'll go with first. After we run out of pre-submitted questions or email-submitted questions, we'll open it up to the audience. So please welcome Mr. Shapiro.
Well, thanks very much for having me. It's gratifying to see this type of audience still interested in the important constitutional issues that this case brought to the fore. I know that you're primarily here for the free lunch and secondarily to hear from Professor Siegel, but I'm happy to be the undercard to the undercard in that proposition. This was a historic case. There's a lot of interesting things about it. Don't take that from me. The court does not often grant 6 hours of oral argument. You literally have to go back to, literally in the real sense of the word, not in the Biden sense of the word, you literally have to go back to Brown versus Board of Education or Roe v. Wade to find something that galvanized the country's political debate and took up so much of the court's attention over the last year. It's also remarkable in that when the litigation started, most mainstream pundits, scholars, didn't give the case the proverbial snowball's chance in hell of making it to the Supreme Court, let alone winning. And there we went up until the final ruling, with the challengers effectively needing, to sweep the board of the Republican-appointed justices on the Commerce Clause, the Necessary and Proper Clause, and the taxing power needed. All 15 of those votes, because of course nobody was talking about, Kagan or Breyer actually finding limits on federal power. It was all about, would Scalia, follow, given his Raich concurrence, would he go along with the government's use of power here? Kennedy, how would he, come out on this? Would the chief join Kennedy, whichever way he went? They needed all 15 votes. They got 14, of course, which with resounding victories on the Commerce Clause, Necessary and Proper Clause, not even getting towards the spending power, which I think is the most remarkable and surprising part of the whole opinion and probably the most practical effect going forward. But of course, there was that one other vote. As I wrote in SCOTUS blog a few days after the ruling, we, meaning the challengers, I filed 10 amicus briefs throughout the course of the litigation, including 4 in this case at the Supreme Court, 1 on each issue that they took up. We won everything but the case. I think constitutional law is left much better off than it was before Obamacare was enacted. On the Commerce Clause, the majority stated that reach was as far as you got. The government could regulate activity but not inactivity, could prohibit existing activity, could regulate it but could not mandate it, could not compel commerce in order to then regulate it in much more clear, sweeping terms than any of the lower courts that had ruled for the challengers, the 3 district courts and the 1 appellate court. That articulation of activity, inactivity, mandate versus prohibition or regulation, that line had not been drawn in the lower courts. They were just saying, well, we can't see a limit on the power that the federal government's articulating, so it has to lose, regardless of what the line is. Here, on the Commerce Clause, the court drew a line. And similarly on the Necessary and Proper Clause, although they're intertwined in this discussion, because what we know is the substantial effects test, right? The federal government can regulate even some types of local economic activity when in the aggregate they have a substantial effect on interstate commerce. But it can regulate those local activities not because they're interstate commerce, but because they're regulating them is necessary and proper to the regulation of interstate commerce. But anyway, there's a separate piece to this ruling that says something might be necessary but still improper. We never had that. That's something new. So whereas on the Commerce Clause we simply underlined what was implicit in the Raich opinion, on necessary and proper we're advancing the ball in terms of putting federal power back into its constitutional box. And as I said, on the spending power, we had 7 justices voting for the first time ever in modern jurisprudence that the attachment of certain conditions, certain strings on federal funds that were being offered to the states were unconstitutionally coercive. The remedy is kind of muddled. I think the court ended up leaving kind of the country in a worse state in terms of this national reform that's going to have a patchwork effect on the states. The states already could choose whether to set up the exchanges or not. Now they can choose whether to expand their Medicaid programming or not. And so we're going to have, rather than a national program that Congress designed, we're going to have some sort of patchwork. And it's unclear from a policy perspective how exactly all that is going to work. Look, there's a word for people who accurately predicted that the legislation would be saved by a 5-4 vote with the Chief Justice providing the decisive vote and Justice Kennedy in vehement dissent. He was the one, Kennedy, read the dissent from the bench that morning when it was announced. And I don't know if any of you, the audio is not available, but if you're reading the transcript, that could have been Scalia. I've never seen Kennedy so passionate and so frankly disgusted with the opinion from which he is dissenting. But there's a word for that for people who claim they predicted that. That word is liars. There's a further word, or at least 2 words, I guess, for those who additionally predicted that the individual mandate would be rewritten and reconstrued and upheld as an exercise of the taxing power. Those words are damned liars. And there's finally a word for those who predicted that in addition to all of that, that the court would nonetheless hold the mandate invalid as an exercise of the commerce power. So, if you hear people saying that the mandate was upheld, the mandate was not upheld. The government does not have the power to enact economic mandates. But who predicted that that would be the ruling on the commerce power, and then hold 7-2 or otherwise that the Medicaid expansion was unconstitutionally coercive, well, I guess the word we're left with for that is statisticians. If you like that joke, good. If not, I stole it from John Elwood from a piece in the Greenbag, so take it up with him. The majority, as I said, the first ever to conclude that a spending condition was unconstitutionally coercive, somehow managed to attract the votes of the two Democratic appointees who seemed most hostile to that argument during oral argument, Justices Kagan and Breyer. You might recall, if you listened to or read the transcript of argument, at some point Justice Kagan said to Paul Clement, well, you know, we're offering you a boatload of money. That doesn't sound coercive. But ultimately, when you get down to the weeds of you know, it ended up being an offer that indeed could be refused. It's kind of like if you're offered, you know, Bill Gates gives you his house, right? Sounds like a really good offer, but then it turns out that you're on the hook for his property taxes and upkeep and whatnot. You know, it's still a really good deal to get this great house for free, but you still can't afford it. That sort of thing. You know, anyway, very unexpected. I think what it shows is that the healthcare cases were plainly part of an elaborate ploy by the court to dampen enthusiasm for installing cameras in the courtroom by making clear that watching the argument actually diminishes one's understanding of what's going on. Nevertheless, I think this case will go down in infamy, in accordance, in a similar way that the slaughterhouse cases, Professor Siegel said he was just teaching that in his previous class, did, and will be discussed for generations by scholars, you know, contending with the important issues of, you know, healthcare, slaughterhouse, is that one word or two, hyphenated or not? Look, having filed all those briefs and written dozens of articles and blog posts and engaged in over 100 public events, I think this is number 109 or 110, on this subject, and having sat through all 87,000 hours of oral argument, I thought I knew what to expect. Indeed, I had writings all the way through 2010, 2011, saying that, predicting that either the court would strike it down or find some technical way of avoiding that ruling, and thus allowing the law to stand without expanding federal power. But I was nevertheless gobsmacked as I was sitting in that courtroom, and I heard the Chief Justice hand the government a bottom-line victory while neither expanding federal power, nor regulatory authority at least, nor dismissing the case on standing, ripeness, Anti-Injunction Act, any one of these procedural technical grounds. I never thought I could feel so empty. I still feel quite hollow. I mean, it kind of, you talk about those stages of grief, right? I think I got past the anger and the denial, but I'm still at the reckoning, the bargaining. After having had the court offer such ringing endorsements of my theories, and not mine alone, on the commerce, necessary and proper, and spending clauses, what had I and everyone else missed? I think it's the possibility that the ruling would be based on something other than competing legal theories. That is, 8 justices decided the healthcare cases on the law. 4 finding that the Constitution limits federal power. 4 that constitutional structure must yield to, quote, Congress's capacity to meet the new problems arising constantly in our ever-developing modern economy. So Congress's powers grow when they need them to grow. And, you know, we can debate those theories. And 1 had other concerns in his mind. I mean, the Chief Justice, of course. It's frustrating that Roberts changed his vote at some point, but that's not my beef. Jurists are allowed to do that, and you know, we've all heard of cases. It's not unusual that judges change their mind, especially in the big, controversial, hard ones. What bothers me instead, having combed through Roberts' taxing power section many times, is that his opinion on the issue simply doesn't compute. It's not a matter of, you know, there are different ways of looking at it. I disagree with that analysis. His opinion just does not hold up. I mean, I can give many examples of this, but for one thing, he talks about a lot how this is not a direct tax for various reasons. Okay, we can agree or disagree, but then what is it? Because the Constitution, why does he talk about it not being a direct tax? Well, because direct taxes have to be apportioned. That means you calculate how much revenue is to be raised, divided among the states and their populations. There's a formula. I mean, obviously the Obamacare tax isn't calculated that way. So what is it then? And that's important because the Constitution only allows certain types of taxes. It's not like, oh, well, if it's a tax, then Congress can do anything. No. Presumably it's not a duty or an impost. We're not importing insurance policies on container ships from China. So it's not a direct tax, he says. So that leaves income taxes. Well, it's not that. Income is part of the formula used to calculate it, but the accrual of income is not the trigger to the payment of the tax. It's your choice, as he puts it, which itself is kind of a problematic characterization. So that leaves excises. Excises are taxes on transactions. Again, he says this isn't a transaction, I guess. Or activity, he says it's not an activity. Is this an excise on the privilege of not buying insurance? I mean, it's not clear. He talks about how there's no scienter requirement, but then he also says that it's a choice between buying the insurance or paying a tax. He says there's no legal consequences for not buying the insurance, but money's fungible. Well, let's say you owe $1,000 in federal income tax and $1,000 in the Obamacare tax. You pay the IRS your $1,000, thinking that you're paying your income tax. The IRS treats that as your Obamacare tax payment, and all of a sudden you still owe $1,000 federal income tax, which has very serious criminal consequences if you don't pay. I mean, there's a whole lot of structural, textual, just basic logical things. I mean, there's a misuse of the constitutional avoidance canon at the very beginning. He only says that he reaches this because he tries to construe it to bend over backwards to save a piece of legislation. But you only avoid the constitutional question when the provision has ambiguous and fairly equal interpretations that are reasonable. Here he admits that it's much more natural to read it as a mandate with a penalty for not complying rather than some sort of tax. I mean, it's unusual. This thing, I call it the unicorn tax, a creature of no known constitutional provenance that will never be seen again. And I don't see it as expanding federal power all too much. I mean, what is the new federal power? For the first time, the court has authorized Congress to levy a very small, not significant tax if you don't do something. So buy a Chevy Volt or an electric car or pay $500. Not $30,000, that would be punitive or coercive, but some small amount. It's kind of a weird power that for all practical purposes will probably never be used. Even Justice Ginsburg expressed skepticism at oral argument and even when she was reading her partial concurrence, partial dissent at this theory. The regrettable inference to draw here is that for reasons of politics or reputation, his own or the court's, Roberts decided at some point that he needed to uphold the law while not expanded federal power. And that's quite a conundrum, and it's why we're left with a ruling hinging on a head-scratching tax on inactivity, a rewritten piece of legislation no Congress would ever have passed, and that's never been seen before. And I'll end with this. The sad thing about this episode is that he didn't have to do it to, quote, save the court. For one thing, Obamacare has always been unpopular, particularly the mandate, which even a majority of Democrats thought was unconstitutional. For another, he only damaged his own reputation by making this move after warnings from politicians and pundits that to strike down the law would be conservative activism or sullying the reputation of the court, regardless of whether that pressure had anything to do with his decision, which I don't think it did, but it looks that way to a lot of people. Which is why the reputation of the court has indeed gone down since the ruling, and it's seen as more political. Perhaps most importantly, the whole reason that we care about the courts maintaining its independence and integrity is that so it can make the tough calls while letting the political chips fall where they may. Had the court struck down the law, it would have been merely a high-profile legal ruling, a big deal, but just the sort of thing for which we want the court to have its institutional gravitas. Instead, we have a strategic decision, or small p political one, or what have you, dressed up in legal robes, judicially enacting a law Congress didn't pass. So what was Roberts saving the court for, if not this big once-in-a-generation case? In short, in refraining from making that tough balls and strikes call that John Roberts discussed at his confirmation hearings, he merely reinforced and showed clearly why we don't want our judges playing politics. Thanks.
Is that 15?
Yeah.
What's that? Well, good afternoon. Thank you all for being here. I'd like to say that I got you that nice lunch, but it wouldn't be true. I want to welcome all of you, and I want to welcome Mr. Shapiro to Duke. This is not our first ACA event together, and it's always good to see him. I hope everyone is doing well. When I say I hope you're doing well, I mean, among other things, that I hope you have health care, because it's an awful thing to live in this country without access to affordable health care. Okay, how many of you folks have not had constitutional law yet? There's no shame, so you can raise your hand. All right, so a good number of you. So I'm going to try and tailor my remarks to you folks, and I think everyone else will follow, will be able to follow along. I want to begin with just some basics of Congress's enumerated powers, define the minimum coverage provision, and then identify the various possible sources of power Congress could have invoked to justify the minimum coverage provision. So it's bedrock law agreed to by both sides in the litigation that the federal government is a government of limited enumerated powers, unlike the state governments that are governments of general or plenary powers. What this means is that the federal government, Congress, can't just pass a law because it feels like it. It's got to find a place in the Constitution that it can use to justify the law. It has to have a constitutional hook to hang its statute on. The states can pass whatever laws they want as far as the U.S. Constitution is concerned, as long as they don't violate independent limits in the Constitution. For example, they can't violate individual rights. Okay, and there are various clauses in Article 1, Section 8, like the power to lay and collect taxes, to pay the debts, and provide for the common defense and general welfare of the United States. The power to regulate commerce among the several states, the power to pass laws that are necessary and proper to carrying into execution Congress's other powers, for example, other concededly valid regulations of interstate commerce. Those are just some of the constitutional hooks Congress has at its disposal in the 18 clauses of Article 1, Section 8, where most of Congress's legislative powers are laid out. What is the minimum coverage provision? The so-called individual mandate, which is a phrase that doesn't appear in the law but was coined by opponents of the law. It requires applicable individuals, most people in this country. There are exceptions for hardship, financially, conscientious religious objections, other exceptions. But the minimum coverage provision requires most of us, most people living in this country, to maintain a certain minimum level of health insurance coverage. That's the minimum coverage provision. And then immediately following that part of the law is the shared responsibility payment, which says that if you don't obtain minimum insurance coverage, then you have to pay a certain amount of money to the IRS each year. It's the greater of about $700 by 2016, or 2.5% of income, whichever is greater, but the amount is capped at the average annual premium for the lowest level of insurance identified in the law. And so what this means is that the amount you have to pay if you don't have insurance is substantially lower than the cost of insurance for many people, indeed for almost everyone. And I think that's important when we talk about whether or not this provision is within the scope of Congress's tax power. What are the three possible hooks for the minimum coverage provision? Common ground in the litigation, it's either the tax power or the Commerce Clause or the necessary and proper clause. It's either part of Congress's power to lay and collect taxes or to regulate conduct that substantially affects interstate commerce in the aggregate, or a law, a provision that is necessary and proper, that is to say convenient or useful, to carrying into execution other concededly constitutional parts of the Affordable Care Act. The very popular provisions that prohibit insurance companies from denying people coverage based on pre-existing conditions, from discriminating and charging higher premiums based on medical history, from imposing lifetime limits on coverage, from canceling insurance in the absence of fraud. And the idea that the minimum coverage provision is convenient or useful to carrying into execution those concededly valid regulations of commerce, because in the absence of something like a minimum coverage provision, we know from the experience in the states that people will act on a rationally self-interested perverse incentive to wait until they're sick or injured to obtain health insurance. If you know you can't be denied coverage, notwithstanding a pre-existing condition, then you're not going to get it until you're in the ambulance on the way to the hospital, and that poses a serious risk of unraveling insurance markets. People who wait to get insurance until they're sick or injured free ride on people who get insurance while they're still healthy. Okay, so that's the basics of Congress's enumerated powers, what the minimum coverage provision and shared responsibility payment are, and what the potential sources of authority for it were in this litigation. Now, I want to turn to some basic arithmetic of constitutional law. Right? And the basic arithmetic is this. Congress needs only one hook to hang its hat on. The government in this litigation had to go 1 for 3. It had to show that the minimum coverage provision is either within the scope of the tax power or a valid regulation of interstate commerce or necessary and proper to other concededly valid regulations of interstate commerce. Those opposing the law had to run the table. They had to go 3 for 3. They had to show that there was nothing in Article 1, Section 8 that justified the provision. And this remains the case regardless of how the debate was framed in the political arena. Think about the word individual mandate. It brings to mind, it presupposes a coercive Commerce Clause or necessary and proper clause regulation. It rules out what this provision actually was, which is a modest financial incentive that, like many other modest financial incentives that are sprinkled throughout the tax code. Okay, so my own view, right? I guess you can accuse me of partisan, small p political motivations, but my own view, recorded in an article that's coming out in the Virginia Law Review this month, is that the minimum coverage provision is within the scope of Congress's tax power, that the Chief Justice and indeed the court got it almost exactly right on this question. Why is that? Well, in order to know whether the tax power justifies the provision, you have to have an understanding and account of what the difference is between a tax and a penalty. If it's a tax, it's within the scope of the tax power. If it's a penalty, then it's either the commerce or necessary and proper clause or nothing. And my own view, which is articulated in this article, it was made available well before the court ruled, and it tracks almost exactly what the Chief Justice and the court, there are 5 votes for this, say, that the difference between a tax and a penalty turns fundamentally on the difference between dampening conduct subject to an exaction and preventing that conduct. The question is, how will this exaction work in practice? How will it operate? That's language from the Supreme Court's case law. What's the practical operation of the exaction, of the amount you have to pay? And if it's going to operate like a tax, have the effect of a tax, then at least for purposes of Congress's tax power, it is a tax. It is constitutionally a tax. The reason why taxes characteristically raise revenue is just because they dampen the conduct subject to the tax. They don't prevent it. If they prevented it, they wouldn't raise any revenue. It's because a good number of people have a reasonable choice to decide whether to pay the tax and engage in the conduct that's subject to the exaction, or whether not to pay the tax by not engaging in the conduct subject to the exaction, that a provision will raise revenue. And so if you look at the minimum coverage provision, what you see is predictions by the nonpartisan Congressional Budget Office that this thing is not only going to raise revenue, it's going to raise a lot of revenue. The CBO predicts that roughly 4 million people each year will choose to go without insurance and make the shared responsibility payment. The CBO predicts that between 2015 and 2022, $54 billion, that's billion with a B, is going to be raised. The difference between a tax and a penalty is the difference between the minimum coverage provision, get insurance and pay about $700, and a different kind of provision, one that said get insurance and pay $20,000. That is coercive. That's going to leave people who aren't Warren Buffett with no reasonable choice but to get insurance. That would be a penalty and beyond the scope of the tax power. And so I agree with Mr. Shapiro that this part of the holding doesn't expand federal power. In fact, I would say that it limits it. And it limits it because there's now a distinction that's part of the law of the land between what is a tax and what is a penalty that justifies this provision, but doesn't justify using the tax power for regulatory purposes. So, for example, the Supreme Court held in a 1995 case, United States against Lopez, that is beyond the scope of Congress's power under the Commerce Clause to ban the possession of a firearm in a school zone. No Commerce Clause authority for that. It's not economic or commercial activity or conduct that was involved in that case. Well, imagine that Congress comes back and says, you can make the choice, as far as we're concerned, to carry a gun in a school zone, but if you do it, we're going to tax that permissible behavior. We're going to tax you, say, $25,000 the first time. And then the next time, we're going to tax you $50,000. And the third time, $100,000. And if you do it intentionally, as opposed to you just didn't know that your boyfriend put a handgun in your backpack, then we're going to tax you even more. That exaction would have all the material characteristics of a penalty, not a tax. It would be much higher than the benefit most people get from engaging in the conduct. It would have scienter requirements and recidivism enhancements. It would see to it that no one feels able to engage in the conduct. That's the difference between a tax and a penalty. All the material characteristics of the minimum coverage provision are those of a tax, and is predicted by nonpartisan CBO to act as a tax. Therefore, it is a tax. Now, those on the other side say, but wait a minute. Congress used mandatory language. It called it a requirement to get insurance. It said applicable individuals shall obtain insurance. It called the exaction a penalty, not a tax. And the question is, should the expressive form of the exaction defeat all the material characteristics and the anticipated consequences? And I think the court got it right that the answer is no. If this expressive language gives one reason to think it's going to act like a penalty, it's going to affect behavior like a penalty, well, then that's a different story. But there's absolutely no reason here to believe that the exaction is going to have that consequence. Opponents say, but what about political accountability? You can't allow Congress to call a payment one thing in the political arena and another thing a court. And it seems to me two responses are appropriate here, and they're responses in the alternative. One is to question the assertion that political accountability is somehow compromised by having the label trump the material characteristics and effects of an exaction. Does anyone not know who is responsible for the Affordable Care Act? Is the minimum coverage provision in particular not still very controversial? And so it seems to me that if you're concerned about political accountability, you're going to care much more about who must pay and how much they must pay, not what Congress calls what they must pay, which I imagine most people don't know anyway. But I think there's a more fundamental response, and that's to question the premise that political accountability is a relevant constitutional value in this context. I know of no authority for the proposition that in order for an exaction to be considered a tax for purposes of the tax power, Congress has to use the T word. That would have been a new requirement imposed on Congress's power that, in my view, the court appropriately declined to impose in this case. Why is political accountability here a relevant constitutional value? Or to put it differently, think about how destabilizing the consequences would be if Congress imposed a magic words requirement, a clear statement requirement. Have you ever taken a look at what's in the tax code? It is a tribute to obfuscation, to subterfuge. How many civilian expenditures are called military expenditures? How many public-minded purposes are used to characterize self-serving log rolls? How much spending is buried in the tax code as opposed to being exposed in the budget? And so if you want judicial review to enforce accountability in the tax code, it seems to me, and if you're going to do it in the principled way and not for this case only, you ought to be concerned about all those practices, which would require a massive judicial undertaking, which presumably no one on the Roberts Court wants to undertake. So that's my view on the tax power. I think the court got it almost exactly right, and not really important to go into the small quibbles that I have with the court's opinion. That was my view before the case came down. It's my view now. A few days before the case was down, I was at the Arizona Bar Convention doing a debate on the Affordable Care Act, and somebody on the other side, I was defending the law, as was a former student of mine from Duke Law School, and then there were a couple of folks on the other side, and one person on the other side first questioned whether my former student was a lawyer, because if you were a lawyer, he couldn't possibly be making such bad arguments. And then I said that, I said you don't get to call me, you don't get to say I'm not a lawyer, but the beauty of America is you get to say I'm a bad lawyer, right? And then when I gave my tax power argument that I just gave to you folks, this individual's response was, this is a loser argument. No court has accepted it. No court's going to accept it. Why are we wasting so much time on it, right? And then a few days later, the court handed down its decision. I thought it was a good argument from the start. Some other legal scholars who are more famous than I thought it was a good argument. It was an argument that the government preserved and expressed throughout the litigation. Okay, so that's what I want to say about the tax power. But let's say you're not entirely convinced. Let's say Congress called it a penalty. The expressive form matters more than Siegel says. What do you do? And it seems to me what you do is consult constitutional law going back to at least McCulloch against Maryland in 1819. And I'm talking about the presumption of constitutionality. This presumption, which has been with us almost from the start, requires judges to presume that federal laws are constitutional when their challenge is beyond the scope of Congress's enumerated powers, and to practice avoidance, to read them in ways that render them constitutional if such a reading is reasonably available. So the Chief said it was more natural to read this as a coercive penalty, not as a tax. He didn't say much more natural, right? But he practiced avoidance. He practiced the presumption of constitutionality, as I think he should. Justice Kennedy said, I know there's a presumption of constitutionality at argument, and then he gave it the back of his hand by saying, in contradiction to what he had just conceded, that don't you bear a special burden, you the Solicitor General, if you're fundamentally changing the relationship between the federal government and the states. Now, how you square a presumption of constitutionality with a presumption of unconstitutionality is not something I'm familiar with. Roberts didn't just give lip service to this presumption, he actually applied it. And I think it's particularly important to apply the presumption here. Adrian Vermeule, who's a law professor at Harvard Law School, former clerk to Justice Scalia, identified what he called the single most important New Deal constitutional convention. And it's the idea that the federal courts, the Supreme Court, should not strike down major social welfare legislation enacted by the federal government. We're talking about deadly serious business. We're talking about the most significant expansion of the social safety net since Social Security, Medicare, and Medicaid. We're talking about the difference between 60 million Americans lacking health insurance in 2022 and 27 million Americans lacking health insurance in 2022, according to the CBO's estimates. So if ever there was a time for the presumption, it seems to me this case was that time. I think the court got it wrong with respect to the commerce and necessary and proper clauses. I'm happy to say why, but I can't do it now. And I think the Medicaid expansion, I actually think raises some very difficult questions about whether coercion is a relevant value here. If this is not coercive, what is? On the other hand, if this is coercive, what isn't? And so that's the subject of my next bit of research, and am reserving judgment on that question for the time being. Thank you.
Why do we care about all this stuff? Why do we have this whole case, the whole litigation? Is it political sour grapes? This was still all legally frivolous and just an attempt to literally relitigate the loss in the really weird loss in the political arena? Or why am I doing this? Why have I spent so much of my time the last 2.5 years focused on this? I'm not a healthcare scholar. I don't even do health law. But the reason why I'm right here and not my healthcare policy colleague is because the case all along has not been about, how many poor children I want to leave out to die in the gutter, or what reform I might have or my colleagues might have in place of this, or is the status quo good? Should we go to single payer? That's not the debate. The debate is about the government the federal government having to stay within its constitutionally authorized power. Why do we care about that? Is that just some sort of pedantry about words on a page, and we're being ultra formalist lawyers or something? No, it's because the Constitution is there first to empower the government to do certain things, to allow us to pursue life, liberty, and happiness, and then to check it. The eternal political theory 101 problem: who guards the guardians? Evoked in our political tradition in Federalist Paper number 51. The whole bit about If men were angels, no government would be necessary. We'd have utopia. If angels govern men, still great. We have perfect government. In the real world, men governing men, you first empower them and then you check them. And the whole Constitution, the structure is there, it gives powers, but then it checks itself. That's the beauty of it. The Constitution is there, as Justice Kennedy wrote for a unanimous court 3 terms ago in the Bond case. The structural provisions, whether it be separation of powers, checks and balances, federalism, are there to protect liberty. And so when the government takes powers into its own hands that it does not get under the Constitution, it is engaging in a form of illegitimate tyranny. That's what this is about. If Congress wanted to have universal single-payer health care under at least modern jurisprudence, it could have. I wouldn't be here. We would have to roll back Wickard versus Filburn and the whole edifice of modern constitutional law, which I wouldn't be against, but that's a completely separate discussion. It could have had Medicare for all, remove the part of the statute, the Medicare statute that says that that's only for 65 and over. It could have added a new payroll tax, actually had a real tax to pay for different things. It could have done any number of things, but that's not what it did. So we're not asking the question of whether what it did do is good or bad. We're asking whether what it did exceeded its constitutional powers because, for the reasons I stated, why we care about the government staying within its constitutional powers. Now, I do hope there are some questions about the spending clause because I think that is fundamentally, for constitutional law at least, more important and trickier and indeed going to be the source of a lot of litigation going forward. But I want to respond to a few things that Professor Siegel said about the taxing power. First of all, on the structural issues that he raised, it was clearly structured not as a tax but as a regulation with an attached penalty. The court has held repeatedly that a tax is a revenue-raising measure attached to certain things, activities, accrual of income, direct taxes on each person, a head tax or property. Here, it doesn't have to be a pure revenue-raising measure. All taxes we know, as we've been taught from law and econ, all taxes have a kind of regulatory incentive effect. But if this tax, if it worked perfectly, would raise exactly 0 because Congress's goal is to have people insured. Have people have health insurance. If this was a revenue-raising measure, then why was it put in the part of the law that has operative provisions rather than in Title 10 that was all about revenue-raising measures? If it was so important and going to raise millions and millions and millions of dollars, then why wasn't it there rather than, in addition to the very small taxes like the indoor tanning services, the Snooki tax, right? That's there, but this huge, important, central tax to the whole thing didn't make it into that. The IRS administering it also, that's a structural thing, but that's not wholly important. You could have IRS enforcing all sorts of things. That doesn't automatically transform it into a tax. The Health and Human Services also administers part of the regulation. Now, real quick, I want to go into this label accountability issue that Professor Siegel raised. Look, to kind of extend the metaphor, this isn't about magic words, but about gauntlets. Okay, if we're going to go into kind of medieval sorcery stuff here. What Roberts allowed Congress to do was to run the easier political gauntlet attending regulatory actions. Taxes are much harder to pass than regulations. And then the easier legal gauntlet by justifying it under the taxing power, which is broader and easier to satisfy from a constitutional perspective than the Commerce Clause. And that's how they did the bait and switch. That's how he avoided the accountability. As far as I meant to stop, one final thing, the presumption of constitutionality, that's a rebuttable presumption. And I think that the challengers here rebutted it sufficiently. If you don't believe in judicial review or that whether it be major, minor social welfare or other type of legislation, if courts aren't meant to review that, I don't know why we have courts. I guess Marbury v. Madison was decided improperly. I mean, look, what we're left here is a ruling whereby the federal government can't regulate inactivity, but it can tax it. I mean, it just makes no sense to me.
Well, let me just begin with that last point. What we're left is a situation in which the federal government may not regulate inactivity, but it can tax it. That makes no sense. That's in the text of the Constitution. The Constitution presupposes that taxation can touch inactivity. That's what a capitation tax is. It's a head tax. It's a tax on existence. And so I think Roberts and the court are
And he explained why this isn't a direct tax.
Okay. That's not responsive to what I'm saying. right? You can tax inactivity under the tax power regardless of whether you can do it under the Commerce Clause. I think Professor Shapiro right that this is a case about powers and limits. I think he is kidding himself if he believes that our own views about the purposes of the Constitution and about the consequences of judicial interventions have nothing to do with what we think is a power and what we think is a limit. So I have my own view about the constitutional structure. Article 1, Section 8 gives Congress broad but not unlimited power to solve collective action problems, to solve problems that the states are not well situated to solve on their own. The problem at the time of the Constitutional Convention was not that the states had too little power and the federal government had too much, and we had to hold the federal government to attack. The problem is that the states were making a mess of things by discriminating against interstate commerce, by free riding on the contributions of other states to the national treasury and to the U.S. military, by the inability of the federal government to tax. And so the Constitution is not only a pro-tax document, it is also a pro-federal government document empowering Congress to protect its citizens when the society faces important collective action problems. I think Justice Ginsburg made, in what is going to be regarded as one of the most important decisions of her career, a very compelling case that Congress reasonably concluded that the problems infecting interstate healthcare and insurance markets are too big in scope and in nature for the states to deal with on their own. They've tried it for decades, and they have failed. With respect to my tax power argument, it seems to me, it's important to focus on just how narrow the objection is. Right? So Mr. Shapiro has conceded, as he must, that Medicare for all, a single-payer system of national health care, is clearly constitutional. It's more coercive than the Affordable Care Act's approach, which provides the preservation of private insurance markets. It's also more centralizing. And nonetheless, that single-payer system of health care for all is clearly constitutional, but what Congress did here is unconstitutional, which is not to say that Congress couldn't have done what it did here. The joint dissent concedes that if Congress had called it a tax, or maybe had put it in a different part of the statute, that would be an exercise of the tax power. And so what Mr. Shapiro is proposing, what the joint dissent is proposing, is that we should impose a requirement for Congress to call an exaction a tax if it wants to be a tax, even though no member of Congress had any reason to believe that that was a constitutional requirement. The court had repeatedly, in a variety of constitutional and statutory settings, followed the basic thrust of tax law, which is substance controls over form. The court has upheld requirements that were structured as taxes, surcharges, fees, right, a variety of different things. And the idea that Congress came this close, but just didn't use the T word, even though it was supposed to, but couldn't have known it was supposed to, and that should make all the difference in striking down this piece of legislation, seems to me to be, that's not judicial review. It seems to me that that is a whole lot of judicial aggressiveness in the service of certain ends. Another point I want to make is that Mr. Shapiro says that the court has repeatedly said a tax is a revenue-raising measure attached to certain things. Of course, there are incentive effects associated with taxes, but whereas I focus on the effects of the exaction, just like the Commerce Clause test is an effects test, he's focusing on intent. What was Congress intending when it passed this measure? And what I want to suggest is that that cannot possibly be right if a variety of payments to the federal government that throughout U.S. history have been understood to be constitutional, for them to be correctly decided. Think about Alexander Hamilton's program for manufacturers, something the Chief Justice cites in his opinion. The federal tax on imports, the impost, that was done both to raise revenues. We got almost all of our revenue early on from impost. It was also done to incentivize certain behavior, to stimulate domestic production. Think about cigarette taxes, alcohol taxes, sin taxes. Think about environmental taxes, taxes that are trying to reduce pollution but not eliminate it. These are all taxes that can be motivated by a number of things, by an incentive to raise revenue, by an incentive to regulate, and they're all considered taxes and they're all considered constitutional. And so it can't be the case that a primary or substantial motive to regulate behavior as opposed to raise revenue is the proper text for the tax power. Mr. Shapiro also said that if this thing worked perfectly, it would raise zero revenue because the goal was to get everyone insured. And I don't think that's right. If that were the goal, then Congress would have structured it differently. They would have said, get insurance or pay $20,000, or get insurance and pay $10,000. This was clearly a compromise to be sensitive to concerns about the coerciveness of the exaction. And so the point is not just to get everyone insured no matter what. It was to encourage or incentivize them to get insured. It would have been more effective in getting more people insured if the amount of the exaction had been substantially higher. But it's just that difference that makes all the difference in the world when one is considering the question of whether the minimum coverage provision is within the scope of the tax power. My view is that the court got it exactly right in concluding that it is.
We've got time for a couple questions. We'll go with the first pre-submitted question, and then after that, we'll open it up. Unfortunately for our two speakers, this question is based more on the marketing than your remarks, but it would be interesting to see your perspective. We said that just because the Supreme Court held the Affordable Care Act as constitutional doesn't mean that it is. A student sent in a question with a pretty big premise, then I'll give you the question. So looking at all three political branches agreeing, or the two political branches agreeing, Congress and the President, that this is constitutional, and then the Supreme Court upholding the law as constitutional in a lengthy decision. So when all three branches of government agree that the law is constitutional, on what basis can one argue that it is not constitutional? Either one of you care to take that?
I don't think you can. I mean, you can say that the court got it wrong. You can say that the President and Congress's evaluation of it was wrong. There are still pending litigation over other parts of it, not the mandate, but lots of other things. One interesting one is the Origination Clause argument that's the Pacific Legal Foundation has a case in the District of D.C. about that, and Oklahoma, I believe, just sued on the same basis. It's a very interesting argument that the Constitution requires all bills to raise revenue to originate in the House. The way that Obamacare was passed, Harry Reid took an unrelated bill, something I think about Veterans Administration, Veterans Affairs, and amended it in the sense of stripping all of it out, including the title, and replacing it with this health care legislation. That obviously violates the spirit of that law. Does it violate the letter of that law? You know, we'll find out. There's never been, this is a fairly common practice in the Senate with very small, not very significant pieces of legislation. It's the first time it's been attempted with something so big that posits this Origination Clause question so squarely. So who knows? As I said, the case that we've just been through was given no chance of getting to the court or winning in any way. So who knows where this will go? But that's it's still possible that parts of the legislation will be knocked out. But I don't think as a matter of basic fact, just like you can't argue that the mandate is anything other than a tax, and it baffles me that the Romney campaign hasn't been trumpeting the importance of the Supreme Court and why we need to get it right, and Obamacare needs to be repealed and that sort of thing more than he has, why he hasn't been using the tax rhetoric. So I don't think you can argue that it's, as a matter of facts on the ground, that it's not constitutional.
I agree with Mr. Shapiro that the fact that three branches say something's constitutional doesn't make it so. My arguments for why I think the court got it right are my arguments for why the court got it right, but they're not parasitic on what other people believe. There has to be a distance between what the court says in the name of the Constitution and what the Constitution means. Otherwise, how do you overrule a Supreme Court decision except through amending the Constitution? With respect to the Origination Clause argument, all I can say is, here we go again. I'm exhausted. I've been doing this for over 2 years. Isn't at a certain point, is it time to stop litigating and start winning elections? Right? I mean, it's not just trivial pieces of legislation. We're talking about one of the tax reform acts during the 1980s. Right? If this Origination Clause argument is right, then that statute was unconstitutional, unknown to anyone. And so we can go back to the beginning and talk about the original meaning of the Origination Clause, but we've been violating its spirit or its purpose ever since. And so are we now going to strike down this law for that reason, like we're going to articulate a distinction between regulating commerce and requiring commerce for the first time for that reason, or imposing a new distinction about what's necessary, concededly necessary but not proper under the necessary and proper clause, and we're going to impose a new requirement that Congress has to use the T word. Right? I mean, at a certain point, right, it's time to stop doing this and move on to other things. Whether the Origination Clause goes anywhere, to me, it depends upon how much the Republican Party gets behind it. Will courts start taking it seriously, just like it depended to a great extent, this litigation, on it becoming the official view of the Republican Party that the minimum coverage provision, which the party itself and conservative think tanks had created as an alternative to the Clinton plan, was now not only unwise but unconstitutional.
Okay, the next question is for Professor Siegel. And you may have already touched on this, but the questioner wants to know what type of tax this is. Like, do you have to characterize it? And then I guess, did you agree with Justice Roberts' characterization of the type of tax? Does it matter to characterize it?
It doesn't matter to characterize it. There's two separate tax questions. And the one I focused on is the question of whether or not, what's the difference between a tax and a penalty? And for that purpose, it doesn't matter how you characterize it. Right? There's a separate question of, is it a direct tax or an indirect tax? And I mean, once again, it's been a very long time in which the court has put any teeth into the direct tax requirement. It's interpreted it extremely narrowly. Right? And so when the joint dissent says that this is a serious constitutional question that the court gives the back of its hand to, this was, it seems to me, wasn't a very strong argument to begin with. But I certainly think you need a distinction between what's direct and not indirect to have a view about whether that part is violated. But I do think they're two separate questions.
Well, I mean, I don't know if that's an argument for some sort of constitutional desuetude or something. You know, a provision hasn't been used or invoked or ruled on in a long time, therefore it sort of goes away, is no longer a part of the valid Constitution that courts are supposed to enforce. I think it's very important to know what kind of tax it is, as I said in my remarks. If it's not a direct tax, and I would quibble with Roberts on that, I think if you interpret it as a tax, it can only be a direct tax and an unconstitutional one because not a portion. But if it's not a direct tax, it's unclear. I mean, he says that there's no guarantee of avoiding taxation on inactivity, and that's true. Capitations are there. But again, he said a capitation is a direct tax, and he says it's not that. So I'm not sure what it is. Government has never taxed a decision not to do something or just the status of not doing something. So, you know, the examples that Roberts gives or that Professor Siegel gave, sin taxes or a tax on buying gasoline, these are taxes, these are excises, taxes on certain types of activity, transactions, that sort of thing. This is something, as I said, I call it half-jokingly the unicorn tax, but it really is something novel.
Congress taxes the inactivity of not getting married because there are certain married couples, particularly if one spouse works and the other doesn't, and they have tax advantages if they get married. And if they decline to get married, right, they're going to pay more in taxes. So it seems to me appropriate to characterize that as a tax on inactivity.
Well, that's a resulting incentive. I mean, obviously, everything that Congress does can be characterized as a tax on something.
Exactly. So now we agree on what the tax power turns on.
We agree on the economic analysis, but not on the constitutional law, which are, you know, it's not mere semantics, because even there's a constitutional difference between tax credits and tax debits, right? Congress can and does give you a credit for, say, putting solar panels on your house. But until this ruling, at least, it was an open question as to whether they could tax you for not putting solar panels on your house. And, you know, Roberts' very quick and dirty back-of-the-napkin analysis of this, I think, leaves much to be desired. If he was really concerned about this, and this is, you know, thought that this was the, you know, the thick hook on which to hang this, then he should have called for re-argument and further briefing and re-argument, because it really was treated as a kind of afterthought, preserved, absolutely, but I think even at its most, the Solicitor General spent maybe 5 or 6 pages of a brief on it, and at argument, it was kind of laughed at by everybody.
Okay, one more question here. How do you draw the line, and I guess this is Professor Siegel first, how do you draw the line between modest financial incentive and coercive tax?
It's a great question, and I can give you an answer in theory, but I can't pretend that it's going to decide hard cases. Fortunately, this is an easy case, right? Because this, so many people, right? This exaction is so much lower than the cost of insurance for so many people that however you enter that question, this is going to fall on the tax incentive side. To me, you look at the material characteristics and you say, how high is the exaction relative to the benefit of most people from engaging in the conduct? You ask yourself, is there a scienter requirement? If you do the conduct intentionally, do you have to pay more? You ask, are there recidivism enhancements? The more you go without insurance, do you have to pay more each month or each year? I think you look at all of these things, but they're going to be hard cases. What do you mean by most people or all people? Right? What do you mean by lower than the cost of insurance for which people? Right? I think these are difficult questions. I think that's right. I think it's also plenty of other difficult questions as well. If you're interested, I can give you, I can give you my paper. But nonetheless, the law deals with this all the time. The courts won't quantify what clear and convincing evidence is, or what proof beyond a reasonable doubt is. They're not going to qualify it because it gives a false sense of certainty or determinacy, which doesn't exist in our law. Nonetheless, there's a difference between the front of your face, the front of your head, and the back of your head, even though no one can identify the precise point at which we've moved from one to the other.
There is no standard. Roberts wrote this as a ticket good for this train only, and I don't know when a future case involving this comes up. It'll probably be under a different composition of the court, and so they'll write whatever the new standard is at that time.
Okay, well, thank you both for joining us today. We really appreciate it. Please.
Produced by Duke University. Online at duke.edu.